Our next speaker is Bill Cronin of Corr Cronin in Seattle. Bill is a fellow in the American College of Trial Lawyers and has been named one of the top business litigators in Seattle in every one of Seattle Magazine's top lawyer surveys since 2001. For 8 consecutive years, Bill has been listed in Best Lawyers in America. He also has been selected as a super lawyer on multiple occasions by Washington Law and Politics and has been named as one of the top 100 super lawyers in the state. Bill has considerable experience representing law firms, accounting firms, corporate officers and directors, and majority and minority stockholders in securities litigation, professional liability litigation, and corporate control disputes. During his career, Bill has represented Exxon, Mobil and Phillips, Georgia Pacific, AT&T Wireless, Champion International, and Amazon.com. Here to discuss some of the ethical issues in internal investigations, please welcome Bill Cronin.
Thank you, Phil. In beginning my presentation today, I'd like to first use a metaphor that I think may be somewhat useful to exploring the ethical issues associated with internal investigations. In a former life, before I went to law school, I actually considered undertaking a profession as a whitewater river rafter. As you'll see in what I'm going to play, I think I made the right decision, and that's why I'm here before you today. But I think that there are parallels that can be drawn between the boatman who's in charge of navigating a whitewater raft through a set of rapids on the Colorado River and the responsibilities that both in-house counsel and outside counsel have in navigating an internal investigation through what is often an ethical minefield in connection with that ethical investigation. And first I'm going to play this piece that illustrates the mishap you have to avoid if you're undertaking an internal investigation.
They're way out there. Doing the right run. Oh my God. Oh my God. Oh my God. They're stuck. Let us take a picture. Oh my God. Get out of there, guys. No, they're stuck. Oh my God. Where are they? Look at the boat.
Now, there's 3 parallels I'm going to draw between the role of the boatman trying to navigate a boat through a set of whitewater rapids and the role that you will have as either inside counsel or outside counsel in navigating an internal investigation to hopefully a ethical and successful conclusion. The first parallel is it's going to be very important that you scout the rapids, or in the case of inside counsel, determine exactly who your client is in connection with an internal investigation. The second thing is will be very important for you in connection with doing the internal investigation to make sure you've got the right investigator doing that investigation and to make sure you've avoided some of the ethical potholes that can arise in an internal investigation. And the third point is that in connection with whitewater river rafting, for example, before you start down the rapids, you must make sure you picked out your potential landing spots if you get into trouble. In the same way, if you're doing an internal investigation, before you start down that investigation, you must have some idea of what you want to do with the report that's going to be produced as a result of the investigation. Now let me turn to some of the ethical rules for you to consider. The first ethical rule that needs to be uppermost in your mind is ABA Model Rule 1.13, which describes what you do when your client is an organization. And there's 3 parts to the rule. First, it requires you, if you're an in-house lawyer, to know that you represent the organization, but to know that your constituency is someone in the organization who can act on behalf of the organization. And who that constituency is can change, and often does change, in connection with an internal investigation. Second thing you need to do under this ethical rule is you have to identify the circumstances that might trigger a need for you to disclose to a higher authority that you have a problem within the organization. And usually the trigger is you have some evidence, some report that someone has violated the law, or is about to violate a law, or has an intent to violate a law, and you believe that's going to cause some substantial injury. If you learn of circumstances like that, you need to report that to some higher authority within the organization. And the third thing that you will need to do is that you will need to identify the higher authority that you're going to have to report to and advise during the course of the investigation. So to put the investigation on course, you need to do three things. You need to identify your client constituency, and it can vary. In my experience, the client constituency can be an audit committee who's overseeing an allegation into potential financial misconduct within a company. In another instance, it could be a CEO who's overseeing an investigation into labor issues at a company. It could be a human resources officer. It could be the board of directors as a whole. In each case, you have to identify who your client is. You have to report to the client what you've discovered. And you have to clarify for all concerned at that time who you can advise and who you cannot advise. And I'll give you an example of how this problem can arise. I had a friend who was general counsel for a young and promising software company in Seattle. He called me. He had a problem. His company was undertaking a number of software development contracts, including one for the Department of Defense. The company was about to go public. They had filed an S-1, they had an underwriter, and they were waiting for the optimum time to go public and hopefully get the maximum price for their stock in the initial public offering. For my client, all looked rosy. But one morning, the CFO came into my client's office, and the CFO announced to my client that he believed that the company was fraudulently billing the Department of Defense in connection with the software development contract that they had. Problem one. Problem two, the CFO had a series of disagreements with the CEO at the company, advised my client, who was general counsel at the time, that the CFO believed that the CEO was directing the fraudulent billing to the Department of Defense for the software development contract. So right at that moment, my client had a problem. He collaborated with the CEO daily. He provided advice to the CFO as needed, and suddenly he had a problem. He had an allegation that targeted the CEO made by the CFO, and he had to figure out immediately who was his client for the purposes of the internal investigation that would necessarily have to follow. The client became the audit committee. My client basically encouraged the audit committee to hire independent counsel. They did, and basically by identifying the proper client and by getting the proper help for the client, my client was able to comply with all the ethical issues that arose in connection with this investigation. But you need to put the investigation on course. Now, for the investigation to be successful, you also need to make a decision about who is going to be your counsel for the purposes of the investigation. And you need to take into account ABA Model Rule 1.7 and ABA Model Rule 3.7. Be careful about who you select to conduct the investigation. In selecting outside counsel, keep three things in mind. If you select a law firm who routinely counsels on the subject matter of the investigation, that may be a risky choice. For example, if the allegation is that the CEO has engaged in financial misconduct, it may not be the wisest thing to retain your regular outside counsel who's been advising the CEO about financial disclosures. Second pointer I give you, if you have a law firm who's counseled the likely interviewees in connection with the investigation, who's been providing advice to them, I do not think you want to retain that same law firm to basically interview them for the purposes of the investigation. And third, if you have an outside law firm who has previously counseled a person, such as a CEO, who is a possible target of an investigation, like in the circumstance I described to you, the selection of that outside law firm is a bad choice for the purposes of assuring your investigation is independent and competent. So beware of the conflict hole in selecting the outside counsel to do the investigation that must be done. Now, I'm going to talk to you about a case that sort of illustrates the problem of selection of outside counsel. This is a series of cases that arose in the state of California. It arose as a result of a scandal associated with the backdating of stock options. There was a district court decision and Ninth Circuit decision on this case. And what had happened is the results of the investigation had been reported to the U.S. Attorney's Office, who then brought criminal charges against William Rule, who was the former CFO for Broadcom Corporation. The basic facts were these. Rule was the CFO of Broadcom. Irell and Manella, a very fine firm, had represented both Broadcom and William Rule as defendants in 2 shareholder lawsuits regarding Broadcom's stock option grant practices. Irell also had been Broadcom's general outside counsel. Irell had also represented Broadcom in the internal investigation that was undertaken into Broadcom's stock option grant practices. And as part of that internal investigation, Irell had interviewed its client, William Rule, as part of its investigation. And when the investigation was over, Irell, at Broadcom's direction, had disclosed the contents of the interview of Rule to Ernst & Young, who were the auditors of Broadcom, the SEC, and the U.S. Attorney's Office. Well, these facts caused a great consternation for Judge Cormac Carney, who was the U.S. District Court judge in charge of the criminal action that the U.S. Attorney's Office had brought against William Rule. And here's Carney's take on what these facts showed. Carney said, a lawyer can never assume a position adverse to a client. No surprise in that. And then he concluded, unfortunately, in this case, a law firm, that was Irell and Manella, had breached its duty of loyalty to a client in several respects. Worse than that, Carney then went on to say, because Irell's ethical misconduct has compromised the rights of Mr. Rule, the integrity of the legal profession, and the fair administration of justice, the court must refer Irell to the state bar for discipline. Fortunately, 3 months later, the Ninth Circuit reviewed Judge Carney's decision and overturned it. And basically what the Ninth Circuit found was that Rule had admitted that he had understood that the interview he had with Irell and Manella, that the contents of that interview would be disclosed to the outside auditors, Ernst & Young. And because of that admission, the Ninth Circuit concluded that Rule could not have had a true expectation that his discussions with Irell and Manella would be confidential. The Ninth Circuit decision was fortunate for Irell, but the facts of Rule illustrate the problem that can arise from selecting as your investigative counsel someone who routinely counsels the corporation, particularly routinely counsels the corporation and the offices of the corporation on a matter that becomes the subject of the investigation. So what's my practical advice for you in that circumstance? I strongly favor that you use special outside counsel to conduct internal investigations that concern potential financial misconduct at the higher levels of a company. And that's sometimes hard to do if you're in-house counsel because you have longstanding and regular relationships with a law firm, but it may well be that that law firm is not the best choice for the purposes of doing an internal investigation if the focus of the investigation is going to be on potential financial misconduct at the highest levels of a company. Now, also in connection with a internal investigation, people are going to be interviewed. And again, the ABA Model Rule 4.3 and the New York counterpart is no different, provides the guidelines for how you deal with unrepresented persons, and they are all unrepresented in connection with the interview process. I believe the best practice, particularly if the internal investigation concerns financial misconduct at the highest levels of a company, I believe the best practice is that you give in writing sometimes what's called as an upjohn warning. Other people call it a corporate Miranda warning. And what the contents of that warning should be is they should advise who the lawyer represents when the lawyer shows up to conduct the interview. I think you also should go further and advise whether the lawyer represents the interviewee, which he does not. And he ought to communicate that, or she ought to communicate that in conducting the interview. You should advise whether the interview is privileged. Usually under the upjohn rule, these interviews are privileged, but the privilege can be waived, and quite often companies make decisions to waive the privilege and produce the report that results from the investigation to regulatory authorities, because that helps establish that there's no reason for the regulatory authority to continue to pursue administrative action against the company. I think it's helpful to advise of the opportunity for personal counsel. And I think it's also important to advise of the possibility that there may be a subsequent waiver or disclosure of the contents of the interview, which will be privileged at the time it's done, but that privilege may be waived subsequently. The final thing, again going back to the river rafting analogy, is when you're rafting a river, and I know this from experience, it's important to know what the landing spot is, where you're going to end up, or what your options are if you get into trouble as you go through those rapids. In the same way, when you're doing an internal investigation, it's important to know and preserve your options in connection with whatever report you decide to generate as a result of the investigation. First, the report doesn't have to be in writing. You may conclude you don't want a written report. So you want to preserve the opportunity not to prepare a written report. Don't tell people you're going to prepare a written report until it becomes clear to you that's the best choice for the company. Second, you should discuss with your client, and again, your client constituency can change. You need to be very careful about identifying who the proper constituency is. You need to discuss who should receive the report. One thing that's happened and reported in the case laws is special litigation committees are often set up to investigate shareholder derivative actions and whether the company should take over the claims that are being advanced by the shareholders in a derivative action. Those special litigation committees will often hire separate counsel for the purpose of investigating the merits of the shareholders' claims. That process needs to be independent of the regular activities of the corporation, and the report of the special litigation counsel should not be shared generally. They should be shared only with the client, who in this case is the special litigation committee, and whoever the special litigation committee decides to share the report with. But inadvertent distribution of the report is a mistake. You also need to discuss reporting responsibilities. If you're a publicly held company, you may have additional reporting responsibilities to the auditors, to the SEC, and perhaps to regulators. And you always need to discuss with your client the waiver issue. In sum, if you embark on an internal investigation, it's important to know who your client is and identify the client with precision. It's important to use, I believe, outside counsel to conduct the investigation. And in certain circumstances, it's important that outside counsel be independent and not have counseled the officers of the company on affairs previously. And third, it's important to keep your options open with regard to the report that you generate. Thank you very much.